Hi, thanks for coming. I'm Diana Mercer, and this is a free mediation orientation. The purpose of this video is to talk about how mediations work and how we do orientations here at Peace Talks. So if you're a practitioner, you may want to emulate what we're doing, or if you're a potential client, this is what would happen if you came to an actual orientation. So I've got a whole list of stuff we'll talk about before you leave, but if you've got questions, let's start there. Well, to be honest with you, an awful lot of people kind of don't know what to ask, so the reaction of, I don't really know what to ask is actually pretty common. If people have questions, it's easy, right? You just start there, because they want to know how long it takes or how much it costs or whatever happens to be on their mind. And the reason for asking for their questions first is so that if they do have something that's kind of preying on their mind, that you actually get it out of the way. So... And really be responsive to them. So doing that really serves a few different purposes. The only embarrassing part about that is that I only thought to do that like last year. Instead of just starting with the spiel, like duh, right?
Yeah.
The whole thing's supposed to be client-centered, so tell me what is on your mind. Okay, right?
Yeah, no. I think that's good.
So sometimes people say just start with the spiel, and so this is why we've got the outline here. So basically, I tell them that the idea behind mediation is that they know more about their situation than anybody else, that the mediators are here to act as a guide and to facilitate and to make sure the communication stays positive, to offer suggestions and all this kind of stuff, as opposed to a traditional lawyer who'd be spending all of your time and money preparing for a case that only has like 2% chance of actually going to court. So that you spend all of your time assuming that you're going to be in that 98% of the people who actually settle. And that we're convinced that everybody who has good information, the right kind of support, and plenty of time to think about it will actually make a good decision. And what we've really seen in the mediation sessions is that people do. I mean, you've been doing this for a long time. How many times do you see people making some crazy decision?
You can always figure out options and ways to work things out. That's correct.
Yeah. No, and most people, I mean, unless they're really messed up, generally, and those people don't tend to self-refer to mediation, so you're never really dealing with that anyway, but, and also sometimes people who are thinking they might give up the farm or do something that's a little out there, usually by the second session somebody's talked to them about it. But that said, if people want to do something that's a little bit different than what might happen in court or a little more generous or not so generous, they will do it here knowing what the law was, what might have happened in court, they will have gotten all of their questions answered, they will have had a chance to sleep on it, and to talk to any kind of a trusted advisor about it. And if they do something unusual, they will know why. And frankly, we do find people doing stuff that maybe is a little bit more generous than the court might have done, but they're doing it feeling like, okay, I know what my options are, I know what the court would have done, I know I don't have to do this, but it just makes sense to me given the situation. And so, people might do something unusual, but they won't do something not knowing that it's unusual. So, there's a lot of fighting in mediator circles about what the right kind of mediation is. On the one hand, there's mediators that don't offer any suggestions and they won't talk about the law. And then on the other hand, there's, experienced attorneys and judges who will be a lot more directive and tell you what would happen in court and then spend the rest of the time trying to talk you into doing that. We try to be a little bit more in the middle. If you're having a great discussion, it's our job to get out of the way. If we feel like you're kind of stumbling or you need a nudge in the right direction, we will certainly jump in and do that. And we do take the legal education responsibility really seriously because an awful lot of our clients don't use outside attorneys, and so we really make sure in an informational way we get people's questions answered. And that if you're interviewing a bunch of different mediators, that's actually an excellent question to ask them because not all mediators do it this way. So that's actually, asking how they work and how much information they use in the room is actually a great session or a great question to ask them in an orientation.
But is it also okay to discuss how that could be one piece of information, and we may also try to bring you other options, especially in the financial arena?
Yeah.
To bring
and I think that's a really
ways of doing things.
Yeah, that's really important.
Okay.
I would encourage people to interrupt with questions if they've got questions that, part of what we do is help you reality test. If a lot of times you think there's only one way to get to where you're going, but like if there was a big traffic jam on the 405, you would take a surface street, or, it might not be kind of the plan A way to go, but you would ultimately get there. So our job is to help you figure out
other options
and different ways of doing things, and maybe something you hadn't even thought about. And if we make a suggestion and you hate it, you don't have to use it. This is not us telling you what to do. The idea is that we're here and it's a dialogue, and that we're helping you figure out what the best situation for you is. And I'm convinced that people who have the right amount of time and support ultimately come up with something that really does make a lot of sense. We don't see people doing crazy stuff. So if people decide to become Peace Talks clients, the way the first session would work is that the first thing we would do when you arrive is we would go over the Agreement to Mediate. You've got a copy in your folder, but an awful lot of people don't read it in advance, which is, it's 10 pages. I probably wouldn't read it either, but you're certainly welcome to, so you've got a copy. But we'll go over that page by page. Usually takes about 20 minutes, and that's completely off the clock. There's no charge for that. And what it does is it makes sure that everybody's on the same page, both literally and figuratively, so that we make sure that everybody understands, in addition to the fees, the office protocols and confidentiality and all this kind of stuff. So then once we get that, all your questions answered with respect to that, and we get it signed, and everybody has a copy, then the next thing that we'll do, we'll go on the clock, and then we'll take a short relationship intake, usually 5 or 10 minutes. Not a real in-depth kind of a thing, but basically what it does is it gives us some insight as to who you are and how we might be able to help you. It helps us gauge your communication style and this kind of thing. And then also if we get to something that is a little bit more challenging in terms of the topics that we're talking about, we have a little bit more insight who you are and how we might be able to help you. Again, we don't spend a lot of time on that, but we certainly ask if there's anything in particular you would like for us to know, and that just helps us know who you are a little bit better. The next thing that we'll do is we'll take, we'll use our agenda checklist, and there's a copy in your folder, to make sure that we catch every topic that you want to talk about. We'll go through it, and it's really a brainstorm list. We'll write it on the board. That list is there just to make sure that we catch everything, but if you've got something that's not on the list, we will put it on the board. The idea is that it's the easy stuff, the hard stuff, big stuff, little stuff, things you may have already agreed on, things that you think you may never agree on. It's really everything. It's a brainstorm list, and then we put it on the board. Then what we'll do is we'll start with the easiest things, and we'll work our way up. What that does is it lets you see that there's progress and that the mediation process works. What it does for us is it gives us a better picture of what's going on in the entire case, and a better opportunity to know about your situation, so that when we do get to the more difficult issues, we've got a much better idea of how we can help you, and some insight into maybe some trade-offs and different things that you could do. Also, things that seem like they might be simple, like checking accounts and who's going to keep which car. If it turns out they're not so simple, that tells us an awful lot of information too. And sometimes people don't want to start with the easiest things, but if they really are easy, we'll get through them really quickly. And then the other problem is if we really did start with the most difficult issue first, we don't really know you well enough in order to know what we could do to help you, and you don't really know us well enough to really trust us with that information. So there's a lot of reasons for doing it in that order. The next thing, usually by the end of the first session, we will have talked about everything. We'll have the easy things out of the way, and we take it upon ourselves to write out good notes so that you don't feel like you have to be writing every single thing down. And then the next thing that we'll do, by the end of the first session, we'll have agreements on the easy stuff, and then the more difficult things, we will have at least talked about everything, what the options are, what some things are you might want to think about, some information you might want to get, and just what the different choices are and what maybe some of the realities and ramifications of those choices are, so that when you in between sessions, you can gather that information or think about it, sleep on it, consider what it is you want to do, talk to your accountant, whatever it is that you will need in order to make a good decision, with the idea being then that we would pick up where we left off at the second session. Now, everything that you've agreed on in that first session, the idea is that it's the building blocks toward your final agreement. But if you don't agree anymore and you want to come back to the second session and you want to change some of that, it's absolutely fine. We just ask that you come with some ideas of things you would do, or ideas, or at least just an open mind about talking about how, things that you would do as opposed to just saying no. Our job, and one of the reasons that there's two mediators in the room, we do everything in a co-mediation model here at Peace Talks. Generally, that's an attorney and a therapist so that we can deal with the legal divorce right along with the emotional divorce. I feel like the complementary disciplines really help us get the full picture. For example, child support is influenced by the parenting plan and the custody, but the custody certainly has roots in child development. The other thing is that we know that everything you're talking about here is really important to you. You're really sitting here talking about everything that you care anything about in the world. And so we really try to honor that and to take how you feel about those topics right along with the legal part of it. The court really expects you to get divorced as a business deal, but you didn't get married as a business deal. So that disconnect, I think, is what gets a lot of people into trouble when they're going to court. At the end of each session, we'll give you a written record of what happened in the session. If it's really straightforward, sometimes we can just copy our notes and there's no charge for that. If there's a lot of moving parts and a lot of kind of half-finished discussions, we'll do a more formal report called a resolution roadmap. It's usually about 20 pages long, and if you need it, you need it. If you don't, you don't. But what I like about creating an institutional memory of a session is that if you go see an accountant or a lawyer or your best friend or whoever's helping you with this, you can hand them that roadmap and you can say, look, this is what we talked about in mediation. Can you help me with this? So that we don't have to worry about remembering it in 4 different ways. We do a lot with legal information and education. We just don't give you legal advice, meaning that we don't take you aside and tell you what we think you ought to do privately. What I like about doing the legal information the way we do it is because we generally stay in the same room together. If you're asking a question, I can say, look, if I was your attorney, this is how I would answer that. And if I was your spouse's attorney, this is how I would answer that. Now that you've heard both sides of the equation and you know what the pros and cons of each side are and where the law stands on that, what do you think? And if it's something that's really simple, we will have a handout. For some commonly asked questions, we've done some research and we have basically a handout that we can give you. But for things that are more complicated, we can help you decide for yourselves what you think the most expeditious way of going about it is, as opposed to, if you're in a lawyer's office alone, and I played this game too, I was a litigation attorney. If I told you that there was a chance you wouldn't win your argument, you probably wouldn't hire me. So, there's a push really to tell you only the good news and to worry about telling you the bad news later. And it's not something that people do, I think, to be nefarious or bad. It's just that there's a push to tell your client what you think what they want to hear ultimately. And we just try to throw the doors open and be as transparent as possible about that. It's our job also to make sure that the discussion is balanced and that everybody's getting a chance to talk. That's one of the reasons there's 2 of us in the room. If you ever feel like it's not balanced and we're not noticing, we certainly encourage you to speak up, but it's our job to keep an eye on that. Like I said, we normally stay in the same room together, but if that got to be too uncomfortable, what we would do is be in separate rooms. Those are called caucuses, and that lets us just talk to each of you privately, and with the idea generally being of coming back in together, but there's nothing less productive than being in a joint session when it really isn't working. So we try to really see what you need as a couple and to design our process around that. In terms of the time and the cost, we book all of our mediations in 3-hour time blocks. So we ask that you allow for 3 hours when you make an appointment. If you don't want or need to stay for the entire 3 hours, then we'll stop when you're done. So maybe after 2.5 hours, you're thinking, I've had it, I can't deal with this one more second, or my brain is full, I can't think about it. Then you would only pay for the time that you actually used. The only deposit we take is a $200 appointment deposit. That holds your appointment date and time, and then it's credited against your last session. Otherwise, it's strictly pay as you go. There's no retainer or big deposit that you pay. So at the end of each session, you'll pay for the time and the services that you asked for us to do while you were here. Most people are done in 2 or 3 of those 3-hour time blocks, mostly spaced over 2 or 3 months, but it's as fast or as slow as you want to go. Our record is 1 hour and 15 minutes, and on the short end and on the long end was about 3 years. But, it's really just what you need as a couple and what makes sense for you. And then at the bottom of the orientation, my accountant has me update this all the time. So to give you an idea I can't tell you how much your case will cost, but I can tell you how much everybody else's cases cost. And 90% of our couples are done for the entire thing, which is all of the divorce paperwork, including the final judgment and stipulation, the $870 of court fees, all the mediation time, and all of the written follow-ups for $9,500 or less. And 50% of our couples are done for $6,500 or less, and that's per couple, not per person. And in any given year, about 8% go over $10,000, and it's never a mystery who those folks are. That tends to be pretty dramatic fact situations or a very, very difficult relationship dynamic. We can do all of the court paperwork for you here. We're not the only place that you can get this done, however, and we do everything completely a la carte. The court requires 2 sets of paperwork. The first set is the petition and the response. That's what gets your case open. The second set is your agreement and the documents that go with that, and that is what becomes your court judgment or your judgment of divorce. If you'd like for us to do it here, we can do it with you here. What we like about doing that is we do it in a neutral way. When you do the petition and the response in court with lawyers, they're not filed at the same time. But when we do it here at Peace Talks, what we do is we have you sign them at the same time, and they're prepared as a mirror image of one another. So you're both asking for exactly the same thing, and because it's happening at the same time, you can really see and hear what is happening with the other person's set of paperwork, and then we just gather all of that and mail it, given the court deadlines and so forth, so that you don't have to worry about any of that. And in addition, with the final agreement, if we come up to something that maybe we hadn't talked about, I'll put that in the judgment that we hadn't talked about it yet, and we would talk about it next time. Whereas if I was representing, let's say you, what I would do is I would write it all up your way and then wait for your lawyer to find it, and vice versa. So I like that we can do that in a neutral way and just bring it up as a question as opposed to some sort of a one-sided thing. And we'll do our best to make sure that you've got the support you need in the room and to answer your legal questions and that sort of thing. But that isn't necessarily a substitute for using your own attorney or accountant or therapist or any other kind of person who can help you through this. We really do suggest that you don't go through this alone. So even if it's a best friend or a family member that you have help you with this, it's really important that you have somebody that you can run things by. Ultimately, mediation is just in my mind, a better process. I was a litigation attorney for 12 years before deciding to do mediation only. And, I really stopped doing litigation because I realized that it just did not help people and that the system was actually making the situation worse. What I can see in mediation is that people are just able to come up with a better agreement and a smarter agreement. It's cheaper, it's faster, it's more effective. People really have input into the final product that becomes the divorce judgment, and it's just a better situation all around. And as much as Peace Talks is a for-profit venture, the vision was to take everything people hate about the family law system and do the opposite. So we try to be really transparent about the fees, like being able to quote you what everybody else's case has cost, and just being really forthright about stuff, making sure that if something controversial is happening, that it's happening with both of you in the room so that we can really work through it and decide what you want to do. It just ultimately is a much better process. We really do try to balance the product and the process. The product is the legal divorce, and in law school they'll tell you that that's 100% of the situation, and the longer I practice, the more I realize that it's less and less and less of a percentage. At this point, I'm pretty sure it's about 20%. But that you really want your judgment drafted tightly. You want the paperwork done right. You don't want to miss any deadlines. That's really, really important. But equally important is how you get there. That you get there in an emotionally sane and whole way, and in a way that lets you start this next chapter of your life without letting your divorce ruin it. Because after all, ultimately you're going to be co-grandparents, and you're going to still be a family, even though it might look a little bit different than what it looked like before. Gosh, I've been doing an awful lot of talking. Do you have any questions, or is there anything that is on your mind that I can help you with?
No, I was just trying to take some notes on some of the stuff you put in between.
I think you can go ahead and stop the tape.
Many times as